They faked my mother's will while I was overseas. My brother Jason and my sister-in-law Mara signed what they called the final document, filed it with the county, and handed a copy to our mother's lawyer. 2 weeks later, they told the judge I had been intentionally cut out. They said it like it was a fact. It hurt because I was the one who paid for Mum's nurse. I was the one who put her name on my lease when she couldn't qualify for renter's insurance, and I was the one who flew home every other month to sit with her in the hospice waiting room. They stole something that had been built out of years of quiet care. I left the country on June 18th, 2019 for a work contract in Singapore. The plan was 18 months, maybe 2 years if things went well. Mum was 75 then, still sharp but slow on her feet. She lived in the house I grew up in, a small red brick on Sycamore Street in Columbus, mortgage-free, modest, market value around $240,000. She had a savings account, a small IRA, and a life insurance policy that named all three of us, me, Jason, and our younger sister Claire, as equal beneficiaries. Mom used to tell me, deadpan, that she wanted things split equally because she didn't like to be asked for favors twice. Before I left, I sat with her in that kitchen and made her write a simple list. Who has the keys? Who gets the photos? Who is allowed to sell what? She scribbled it on a Post-it, and we both laughed about how precious it looked under the magnet shaped like a rooster. I assumed we all knew the rest. The lawyer had said we should update formal documents when I came home for a visit. I told myself I'd have time. When Mum's situation changed, bad fall in the winter of 2020, diagnosis that made her forgetful, I started wiring money. I paid $1,200 a month for a visiting CNA. I covered the medication that Medicare didn't fully reimburse, and I transferred $6,500 the fall she needed, a hospital stay. Jason lived 5 minutes away, and Mara ran a small daycare out of their house. They said they'd check on her. They arranged groceries, drove her to appointments, and posted photos of her on Facebook when she smiled at a new dog filter. They were the ones who told me to focus on work, that Mom was in good hands. Power imbalance is a hard thing to name when you're the one asleep in the other room. I was across the world, earning in dollars that converted well, but distance meant I had to rely on phone calls, on their updates, on PDFs, and photos. I had no power of attorney at the time. Mum had been stubborn about paperwork. She said legal forms felt like admitting defeat, and I let it be. Signing a POA would have felt like moving in. I was paying cash for care. I trusted the people who visited her daily. The first blow came in an email at 3 a.m., my time. It was from our mother's lawyer. Attached is the last will and testament of Margaret Hale, dated October 5th, 2021. Please let me know if you have any objections. The PDF had a scanned signature and a notarization. The will left the house, all savings, and the policy proceeds to Jason and Mara. It named them as executors. No mention of me. No mention of Claire. I sat in the guest room of the apartment complex where I was living and stared at the screen. I remember the clean way the file opened, the exact shade of the office lamp reflected on the scanned paper. I remember thinking there had to be an explanation. Maybe Mom had changed her mind. Maybe she had told me in a private call I forgot. Maybe some late night conversation I couldn't recall. I called Jason. He said he had a copy, that Mum had asked them to help with paperwork, because she didn't want to leave instructions that might confuse anyone. He sounded calm. He sounded like my brother. They must have filed the will on October 7th, 2021. The probate office stamped it and scheduled a hearing. 3 days later, Mara posted a photo on social media of our mother smiling, captioned, "Finally at peace." Someone had taken my seat at the kitchen table and set a napkin on it. My reaction then was a cold, practical thing. I hired a probate attorney in Columbus, a woman named Elena who had a reputation for not wasting time. She charged a retainer, $5,000 upfront, and told me to get whatever evidence I could: bank records, caregiving logs, emails, texts, photos, anything that showed Mum's capacity and the timeline. I wired the retainer that day. It hurt to see my savings dip. It hurt more to feel like I was being billed for my mother's life. Escalation began almost immediately. Jason and Mara did not wait for me to fly home. They changed the locks at Mum's house under the pretense of safety and left a note, a typed letter, that said we were keeping the affairs orderly. The CNA, who had been coming 3 times a week, texted me that she had been told to stop by Mara, who said the family lawyer instructed her to maintain a visitor list and keep Mum on a more restricted schedule. The bank froze the joint checking account when Elena filed an emergency petition to prevent withdrawals, then allowed Jason to withdraw $20,000 the next week under a temporary access clause. He claimed it was for medical expenses. 2 days later, I found wire confirmations for $8,000 that landed in an account under Mara's name at a credit union across town. Every new thing they did felt like a small mechanical cruelty. They filed an affidavit from a neighbor claiming Mom had clarified her wishes at a picnic in September. The neighbor, Edna, had always loved a casserole and never missed church, but she didn't come to the probate hearing. Elena tracked down the records of Edna's statement and found it was written the day after the will's date and had only a vague reference. I remember watching the PDF with the highlighted sentence and feeling the air narrow. They also started to rewrite the story people told about me. At every family gathering I had missed because of work, they painted me as the absent daughter who only called when she needed money. They said I had abandoned Mom to chase a paycheck. Old friends who used to text me about soccer games began to avoid me when I called. The mother of a childhood friend told me, apologetically, that she had heard things. That my brother and his wife were worried about outside claims. I tried to explain. The explanations were always too long for voicemail. The second wave came when they began to use paperwork and professionals to shore up the lie. Mara produced a notarized document, a short addendum that clarified certain bequests, and a doctor's declaration that Mom had been lucid when she signed. The doctor's letter used the same phrasing as the notarized addendum, capable of understanding and directing affairs. Elena's investigator, a patient woman named Roger, drove to the clinic. He returned with a notation in the clinic's binder that contradicted the letter. The clinic's chart showed multiple missed appointments and that Mum had been disoriented on the days in question. The doctor revised his statement citing a miscommunication. I paid Roger out of the money I had saved for a security deposit on a place I did not yet need. They also turned friends into witnesses. My cousin Claire became a problem. She had always been the most pliant member of the family, the one who wanted no conflict. She told me over a choked phone call that Jason had explained the situation and that when she came around to Mum's place, Mum had seemed happy. Claire said she didn't want to be in the middle. I remember her voice breaking and then the line going dead. The sense of being isolated metastasized into a physical ache. The court calendar moved slowly, which meant the pressure was constant. While we waited for hearings, Jason and Mara began selling things out of Mum's house. They listed the old oak dining table on Facebook Marketplace, and the buyer arranged to take it with a moving truck within a week. The buyer gave them cash. They sold a set of silverware that had been my grandmother's. They boxed up the photo albums and put them in storage under a company name that returned no online footprint. And every transaction they made, they justified as preparing for estate settlement. I'd paid for a lot of what kept my mother alive, but I had no standing to stop them without a judge's order. I wanted leverage, and then I had none. Traveling back from Singapore cost money and time off. My company was strict about unapproved leaves. I tried to take unpaid leave, but the HR department was blunt. 3-week maximum for family leave. Documented emergency. Elena told me to hold on to my passport for now. She said we needed time to build evidence that the will was forged, that you couldn't simply strip people of property without proof. We tried to subpoena the notary. The notary said she had notarized a signature witnessed in person. The notary's ledger, the handwritten book that shows who signed when, was presented as a supporting document. It matched the will's notary date. The court clerk's seal looked official. My chest tightened. I felt small and very far away. They doubled down on narrative control. At the probate hearing, Mara's lawyer described me as a woman who had disappeared into her own life. He painted me as the sort of person who would suddenly claim inheritance after years of absence. He asked the judge to accept the will as a clear expression of Mum's intent. His tone suggested that any opposition was selfish. A cousin I had meant to trust stood in the courtroom and called me on my phone live to ask if I had a point. I didn't, not in that moment. Elena objected. Elena made motions we needed, and the judge continued the case to allow for discovery. We were buying time and bleeding money. A few small things went wrong for them. One was a digital one. I had, without thinking, backed up a voicemail from Mom on an old cloud account. A short message she left the Christmas before she fell. "Hey Em, call me when you can. I love you." The file's timestamp was December 12th, 2020, and its metadata showed it had been created on my phone locally and then uploaded to the cloud 2 hours later. It was a small human thing, hardly evidentiary for wills, but it showed ongoing contact. Elena filed it. She called it proof of relationship. The judge glanced at the phone transcription in the folder and frowned in a way that felt like a small victory. Another fracture in their story came from a bank teller. A teller at the credit union noticed that a series of deposits and withdrawals around the will's date were inconsistent with typical caregiving expenses. The teller asked questions. The credit union opened an internal inquiry, and suddenly a ledger that had seemed tidy was messy. One deposit was from a limited liability company registered to a neighbour of Jason and Mara. That neighbour's name came up in discovery as the person who had moved some of the big furniture. We got subpoenas back showing wire transfers that did not match the stated purposes. It didn't prove forgery, but it showed movements that needed explaining. They reacted to every crack with louder assurances. They gave interviews to relatives over dinner about how we only want to honor Mom's wishes. Mara posted a long message on Facebook about protecting the family legacy, and the comments flooded with platitudes. A cousin I hadn't spoken to in years wrote, "You're doing the right thing." Their lawyer began to yell in closed sessions. Words like efficiency and closure were thrown around like shovels. I kept counting receipts. As the hearings went on, the pressure came at me in other ways. My employer told me they needed me in Singapore the following month for a product launch. Elena wanted me present in court for the next set of depositions. I had to choose one. The choice was cruel and compressing. I booked a flight to Columbus and used 2 weeks of unpaid leave. I came home with a carry-on and a lawyer's number burned into my brain. The low point happened in a grey, dull week in March. We had a hearing scheduled and I had arranged to stay at a small motel near the courthouse. I arrived in town on a rain-smudged morning. I went to Mum's house before court because I needed to see the rooms. The red brick looked smaller. The lawn was cut. The hydrangeas dead from winter, but the porch light was on. I expected to see the house as it had been, if only out of stubborn hope. Inside, it was staged. The couch had been replaced. The family photos I remembered on the mantle were gone. In their place were what looked like rental pictures, glossy landscapes no one in our family would choose. The kitchen smelled faintly of lemon cleaner. There was a pile of boxes in the study labeled in neat print. Estate, J and M. I walked through and touched the banister, where my hand had always fit, and felt the scratch of varnish. My hand shook enough to blur the seam. At the courthouse, the judge looked tired. Jason sat next to Mara, his presence like a steady machine. They had hired a private investigator who made a dramatic claim that he had found a signature sample from Mom dated the same year that matched the will. Eleanor objected to the sample's provenance. The investigator slammed down a photocopy and said it proved capacity. The judge allowed it as part of the record. I felt my leverage slip. Without clear new proof, without a smoking gun, the balance favored the people physically present and well-funded. That night alone in the motel, I sat on the bed and let the quiet do the worst work. The motel TV hummed late-night news. My phone had 1 missed call from Claire and 3 new messages from Eleanor with redaction notices attached. I had already spent $22,000 on legal fees and the suits that I couldn't postpone. My company told me to decide whether I could commit to the product launch. The bank put a temporary hold on some of the estate funds, but the house was still listed as prepping for sale in a public real estate database. I slept at the edge of exhaustion. When I woke, the weight of that small, sharp isolation was the only thing that felt true. Then a mistake happened. It was the kind of mistake that comes from human impatience. Jason, in his rush to make things feel finished, used a scanner at the county office to make a PDF of the will to send as a courtesy copy to a potential buyer of the house. That scanner, a cheap 3-in-1, embedded metadata into the file, the model name, the software that created the PDF, and the exact machine-generated date and time. Elena's technical consultant, a woman named Priya, who understood file systems the way some people understand wood grain, ran the PDF through forensic software. The document's metadata showed it had been created on October 12th, 2021, 5 days after the notary's ledger entry. When Priya compared the ink composition to known signatures, and she found differences in pressure and stroke direction. I didn't jump up and shout in the park. What I did was send Elena a message that said, "We may have something." She wrote back, "Get to Columbus." I booked a cheap flight for the next morning. The turning point was a small, concrete thing, a voicemail. It didn't come from Jason himself. It came from Mara's brother, a self-important man named Peter, who liked to record his victories. In one of the many depositions, an audio file from Peter's phone had been entered as evidence. In it, loud and breathless, he boasted to a friend that, "We got it done, the lawyer filed it, and Jason handled the rest. You'd be proud." Elena played the audio in a room that smelled like coffee and paper. I sat there and felt the sentence land with a physical certainty, so it was the line I had been building toward without knowing. It was not an eloquent confession. It was a brag. It was the exact kind of evidence that turned suspicion into a prosecutable pattern. Once that audio was in the record, other details aligned. The notary's ledger showed that on the date in question, the notary was out of state, according to her own hospital records. A neighbour came forward quietly, tears in her eyes, and said she had seen Jason carrying a cardboard box into the house on October 6th with what looked like office supplies. The bank revealed internal notes from an employee who had flagged several withdrawals because check numbers did not match the signature file. Every one of those items was small alone, and together they mapped a seam. The probate judge put an emergency freeze on the estate and ordered an independent forensic document examiner to analyse the will and its attachments. The examiner's report was methodical and technical. Ink chromatography, pressure analysis, metadata timelines. And when Elena summarised it in plain language for the court, the room went quiet. The examination found ink inconsistencies, a notary entry that couldn't be reconciled with the notary's location, and a scanned copy whose metadata contradicted the claim signing date. The judge voided the will provisionally and appointed a neutral administrator to oversee the assets while criminal authorities were notified. I expected fireworks, and there were none. There were orders, subpoenas, and a steady legal machine moving through its paces. There were police interviews and recorded statements. Jason and Mara tried to claim they had acted in good faith, that Mum had told them informally, and they had only been trying to honour her wishes. The prosecution was not in love with spectacular sentences. They were interested in proof and restitution. Faced with the chain of evidence, digital metadata, the notary's contradictory ledger, Peter's audio, the prosecutor offered a plea deal: guilty to misdemeanor forgery and fraud, restitution to the estate, and community service. Jason and Mara took it. The consequences were not dramatic acts of revenge. They were slow and administrative. The credit union placed liens on some of Jason and Mara's personal property to satisfy restitution. The storage unit where the albums had been kept returned the boxes after a court order, though a few photographs were missing. The dining table was recovered from the buyer. He said he had bought it in good faith, but returned it reluctantly when shown the court's order. Several of the larger items had been sold and could not be recovered. The county issued orders that compelled Jason and Mara to pay back the sales value as restitution. They had to reveal financial records, mortgage statements, and credit lines. In the end, they ended up selling the house on Sycamore Street to cover the restitution and legal fees, and after title transfer, there was nothing left for them to control. They ended up with debts they had to pay. There was also social consequence. People chose sides in small towns in ways that feel old and wearying. Some friends who had offered support to Jason and Mara began to avoid them once the plea deal was public. Their daycare lost a long-standing client when a parent refused to have their child in a setting run by someone convicted of fraud. Jason's construction job, which had been steady for years, terminated his contract after the background checks revealed legal trouble. Mara found it harder to enroll children without parents asking questions. Those things didn't erase the hurt they had caused, but they mattered because they shifted the power dynamics from them to other institutions. Institutions can be slow, but they are also durable. Legally, the final outcome was a return to a default state. The court acknowledged my standing as a rightful heir under prior agreements, and the life insurance policy reverted to its original beneficiary allocations after the forged will was voided. The house sale paid off the restitution with a little left over that the administrator divided among the rightful beneficiaries. We did not get back what had been sold and spent years ago. Vacations, gifts, the petty cash Jason had used for surprise bills. The family photograph album had gaps. That absence is different from physical loss. It has edges that sting in certain conversations. Emotionally, the consequences were quiet and complicated. Jason and Mara and I rarely spoke after the plea. Claire and I tried to rebuild a relationship that felt honest without pretending the past had not happened. Mum's house is no longer ours. The new owners, a young couple with a dog, painted the porch and have photographs of their own. I drove by once and felt a soft grief that did not explode. It sat like an old bandage. I learned, in a legal sense, that systems can correct fraud once enough evidence is collected. I learned in a personal sense that trust, once broken, leaves a bruise in places you had forgotten to check. There is a strange private satisfaction in watching a ledger be examined and seeing how much the truth depends on small technicalities. But satisfaction is not the same as triumph. I lost time with my mother. I lost objects I cannot quantify. I lost the easy habit of assuming family equals safety. There was one quiet restorative thing, a small ceremony in the probate judge's office where, under a grey January sky, the administrator handed me an envelope that contained a portion of what was left. It was not a moment of triumph. No one cried or raised fists. We signed forms and shook hands. I felt relief more than anything. The relief was slow, like a winter thaw that begins at the roots. In the months after, I took stock of what remained. I returned to my work contract for another year because financial obligations do not pause for family drama. I found a therapist who helped me speak about boundaries in a way that did not make me feel guilty. I started a small monthly fund to pay for a visiting nurse for the neighborly elderly woman down the street. It was modest and anonymous. I bought a scanner and learned how to keep redundant backups. I called Mom's old friends and listened. I repinned a few of the photos we recovered on a corkboard in a way that left space for missing faces. When people ask if I forgave them, I tell a practical truth. I do not owe anyone the surgery of feeling something they do not deserve. Forgiveness is not a requirement for my life to move forward. I did not get the family I hoped for back, and I do not pretend it is healed. The pragmatic repairs within the system, the restitution, the court orders, helped me reclaim the practical parts of what was taken. The emotional parts are still inventory in progress. The last time I saw Jason was at a mediation session where we sat across a table under fluorescent lights. He looked older by a few years, as if the small town gossip had been a slow erosion. He offered no grand apologies, only statements that sounded rehearsed. Mara kept her gaze on the table. I did not raise my voice. I did not need to. Legalities were signed. The mediator shuffled papers and told us what would happen if either of us failed to meet the terms. That, in the end, was the instrument that enforced consequence. The impartial rule of documents. I tell you this not to claim a victory of righteousness, but to describe the way ordinary institutions can be the avenue of remedy when the people you loved become the ones who hurt you. It took financial cost, stamina, a good lawyer, and the luck of a recorded voicemail. It took a chain of small weaknesses to produce a decisive seam. Now, in the quiet after, I find myself doing small, practical things. I sit with a cup of tea and look at the corkboard with the photos we recovered. I keep a folder of digital backups in 3 places. I answer calls from relatives without a flinch. I learned how to say no when someone suggests that I give up on a claim because family is family. Family is family, yes, but it is also people who must be accountable. If you've stayed with me this long, I want to leave you with one concrete note. These situations are rarely fixed by courage alone. They are fixed by records, by details, and by persistence. I collected emails, bank statements, voicemails, and the patience to hand them to someone who could translate them into legal language. That's the straightforward, unromantic truth. If you found this story meaningful, please leave a like. If you want to hear more stories like this, subscribe. I share them because they are not polite stories. They are the ones that have fingerprints on them. And if you've ever had to fight someone close to you for what's rightfully yours, I'd like to hear about it. Leave a comment below.